Reading Appropriation Language. Module 3. Permanent Budget Authority.
Module 3. Permanent Budget Authority. This is the third in a series of 3 modules on reading appropriation language. In modules 1 and 2, we discussed the appropriating language of the 2 types of current budget authority: regular, including supplemental appropriations, and continuing appropriations, a slightly different, though still all too common, way of providing appropriations. These 2 forms of current budget authority are the most common means of providing appropriations and the ones we're most familiar with. In Module 3, we'll discuss the language of permanent budget authority. This is budget authority that's available as the result of previously enacted legislation. As we will see, this type of language generally lacks the consistent structure that we've seen in Modules 1 and 2. Let's get some perspective on the universe we're looking at. Roughly 54% of HHS unexpired accounts receive current budget authority, and 46% receive permanent budget authority. In order to get a better understanding of permanent authority, let's return to GAO's glossary of terms used in the federal budget process that we reviewed in Module 1. Recall that GAO defines appropriations as budget authority to incur obligations and to make payments from the Treasury for specified purposes. It goes on to say, an Appropriation Act is the most common means of providing appropriations. However, authorizing and other legislation itself may provide appropriations. Let's return for a moment to our pie chart. About 54% of HHS unexpired accounts receive funding from appropriation acts. This same 54% receive funding under continuing resolutions when Congress fails to enact regular appropriations on time. So the accounts covered by Modules 1 and 2 are all represented by the blue slice of the pie. The other 46% of HHS unexpired accounts, the red slice, receive funding from authorizing and other legislation, otherwise referred to as permanent budget authority. This module will focus on the language that creates permanent budget authority. Let's summarize in a chart what we've covered in Modules 1 and 2. Modules 1 and 2 covered the appropriation language that provides funding for annual appropriations acts, including continuing resolutions. We mentioned that the funding provided in these vehicles can be classified, thanks to the Budget Enforcement Act, as either discretionary or mandatory. Because such appropriations are made for the current year in annual appropriations acts, including continuing resolutions, they are referred to as current authority. Another way to distinguish this funding is to refer to the discretionary funding as discretionary spending and the mandatory funding as appropriated mandatory spending. Some programs in this category, like Medicaid, are referred to as appropriated entitlements. But since not all annually appropriated mandatory spending is the result of an entitlement, it's more accurately referred to as appropriated mandatory spending. Such funding may also be distinguished by whether it's definite appropriation or capped, or it's an indefinite appropriation and is open-ended. There are a lot of examples of definite or capped discretionary appropriations. In fact, virtually every discretionary HHS appropriation made available in annual appropriations acts fits in this category, including FDA's salaries and expenses, NIH's research grants, general departmental management, and so on. Examples of definite or capped mandatory appropriations include social services block grant, payments to healthcare trust funds, excluding the Part B matching payments, and a portion of the Promoting Safe and Stable Families account. Examples of indefinite or open-ended mandatory appropriations include Medicaid, child support enforcement, foster care, retired pay, and payments to healthcare trust funds, Part B matching payments. In modules 1 and 2, we saw fairly standard and predictable language employed in appropriating these types of funds for the current year in both Appropriations Acts and continuing resolutions. But things are about to change. In Module 3, we're covering the language in permanent budget authority, primarily appropriations. Permanent appropriations are the result of previously enacted legislation and are available without further legislative action. Since the Balanced Budget Act was passed, permanent appropriations have been referred to as direct spending. In fact, because these permanent appropriations are not part of the normal congressional appropriations process, they are sometimes even referred to as backdoor spending authority. But direct spending is a bit broader than our topic, so let's parse out what's meant by direct spending so we can focus on that portion falling under our topic. First of all, in the Balanced Budget Act, now codified at 2 U.S.C. 900, Congress defines direct spending as 3 components. Budget authority provided by law other than appropriation acts, entitlement authority, and the Supplemental Nutrition Assistance Program, or SNAP. This used to be called the Food Stamps Program. Let's map this out. We have our 3 components. For our purposes, we'll ignore SNAP for a couple of reasons. First, it's an outlier to the definition, and second, it's not an HHS program. Budget authority comes in 4 forms: appropriations, contract authority, borrowing authority, and spending authority from offsetting collections. There are no instances of the use of contract authority in HHS, and the small amount of borrowing authority used is associated only with loan revolving funds, a form of spending authority from offsetting collections. So since our primary topic in these modules focuses on appropriation language, the appropriation is the form of budget authority we'll primarily focus on. Once we've finished our discussion of appropriation language, we'll spend a little time on some of the language you might come across that provides spending authority from offsetting collections in permanent law, just to complete the picture. But for now, let's focus on 2 major categories: appropriations provided by law other than appropriation acts, and entitlement authority. We've spent a lot of time in modules 1 and 2 talking about appropriations, but what is this entitlement authority? Congress defines entitlement authority as the authority to make payments, the budget authority for which is not provided for in advance by appropriation acts, to any person or government if, under the provisions of the law containing that authority, the United States is obligated to make such payments to persons or governments who meet the requirements established by that law. Note that entitlement authority by itself is not an appropriation, but since an entitlement requires the government to make a payment to an entitled person or government, and since no money can be drawn from the Treasury but in consequence of appropriations made by law, Congress basically has no choice but to appropriate funds to cover entitlement payments. We've already talked about the appropriation of funds for some entitlement programs in annual appropriations acts, such as Medicaid, child support, and foster care. But most entitlement appropriations are made in permanent law. So let's simply distinguish between non-entitlement appropriations or appropriated mandatories and entitlement appropriations. Each of these can be divided into definite or capped and indefinite or open-ended. Examples of definite or capped non-entitlement appropriations include healthcare fraud and abuse control, or HCFAC, state grants and demonstrations, Indian Health Service and National Institutes of Health diabetes programs, and most Affordable Care Act appropriations. Examples of indefinite or open-ended non-entitlement appropriations include the American Health Benefit Exchanges and the Quality Improvement Organizations, or QIOs. Examples of definite or capped entitlements include the Child Health Insurance Program, CHIP, the Temporary Assistance to Needy Families, or TANF program, Child Care Entitlement, Abstinence Education, and World Trade Center. Examples of indefinite or open-ended entitlements include Medicare and Social Security. Before we look at the different types of language that we may encounter, let's review our summary chart of the elements of appropriation language from modules 1 and 2. Because the title of Appropriation Acts requirement in the Dictionary Acts applies only to what else? Appropriation Acts. And because we are now discussing appropriation language provided by laws other than Appropriation Acts, it should come as no surprise that this requirement does not apply to permanent appropriations, whether entitlement or not. However, the enacting clause requirement in the Dictionary Act applies to all acts of Congress. Since permanent appropriations occur in an act of Congress, this requirement still applies. Since a joint resolution is typically not used for permanent appropriations, a resolving clause would not apply. Because the Constitution requires an appropriation for money to be paid out of the Treasury, some statement of appropriations is required. Though we will see the wording varies greatly, keep in mind that language appropriating funds in permanent law is written by different people than the language for regular, supplemental, and continuing appropriations. Recall from the introduction that an appropriation made by law is a legislative authorization prescribed by the Constitution for money to be paid out at the Treasury. To satisfy this clause, Congress needs to specifically use the term appropriate or enact a law expressly directing a payment out of a designated fund or source in the Treasury in order for us to conclude an appropriation has been made. You will also recall from modules 1 and 2 that in regular, supplemental, and continuing appropriations, the statement of appropriations in a very neat and tidy way makes this very clear. This statement is easy to locate because it typically occurs once at the beginning of the legislation and is intended to broadly refer to all of the appropriations following. The wording is typically, the following sums are appropriated out of any money in the Treasury not otherwise appropriated. With CRs, you might see the word hereby inserted and text added out of any applicable corporate or other revenues, receipts, and funds for the several departments, agencies, corporations, and other organizational units of government. With permanent appropriations, finding appropriation language is not as straightforward. Typically, permanent law appropriation language appears in sections titled Appropriation, Funding, Implementation Funding, Funding for Technical Assistance, and so forth. And this may occur in the middle of programmatic legislation. In searching for appropriation language in permanent law, I typically do a text search for appropriation or funding or for dollar amounts. You also need to be aware that most permanent law appropriation language is ultimately codified in the U.S. Code. Since all amendments are reflected in the codification, you get a much more complete picture of the appropriation. This can be particularly helpful to see how subsequent amendments affect the language. For example, let's take a look at the history of appropriations for abstinence education. Here is the original appropriation in fiscal year 1996. Since the original appropriation ended in 2002, here we see amending legislation in 2003, extending the funding through 2003. Then, in fiscal year 2010, the funding was extended by amendment to fiscal year 2014. In 2014, an amendment extended the funding through 2015, and in 2015, an amendment extended the funding through 2017. Note, the newly codified version in 42 U.S.C. 710 has the most recent date of extension and also a list of all the legislation. Let's get back to our discussion of appropriation language. Since the appropriation language in permanent law applies only to a specific appropriation amount and does not follow the unnumbered paragraph format of an annual Appropriations Act, the first difference you will notice is that the statement of appropriations doesn't typically use the phrase "the following sums." You may see "there are appropriated," or "there is appropriated," or even "there shall be appropriated," followed by "out of any money in the Treasury not otherwise appropriated," or "out of any funds in the Treasury not otherwise appropriated," or the phrase "out of any money in the Treasury not otherwise appropriated," or "out of any funds in the Treasury not otherwise appropriated" may appear first in the Statement of Appropriations, followed by the declaration of appropriation with either a proper plural "there are appropriated," or singular "there is appropriated" verb. Drafters of permanent appropriations do not appear to be grammar Nazis, nor do they appear to care very much about following any standard format in the Statement of Appropriations. In some instances, an authorization may precede the appropriation. In such cases, you may see the phrase "there is authorized to be appropriated," or "there are authorized to be appropriated," followed by "and there is appropriated," or "there are appropriated." They seem to have a lot of trouble with "is" and "are." And also keep in mind that permanent appropriations are frequently made from trust funds. Because the movement of funds between trust funds and general funds involves an expenditure transfer, such appropriations are typically worded as "the Secretary shall provide for the transfer from the relevant trust fund to a recipient account and an amount." As you can see from all these examples, drafters of permanent appropriations do not seem to care about following any standard format in the Statement of Appropriations. So there's not much consistency in these statements. But the important point is that all these variations work. as long as Congress specifically uses the term appropriate or enacts a law expressly directing a payment out of a designated fund or source in the Treasury. Let's take a look at a few samples of the Statement of Appropriations of Permanent Authority. Note that the HICVAC language is "there are hereby appropriated," and in this case is appropriated from the trust fund, the Hospital Insurance Trust Fund, and not out of any money in the Treasury not otherwise appropriated, which typically refers to the general fund. State grants and demonstrations language is out of any funds in the Treasury not otherwise appropriated, there is appropriated. The exchange grants appropriation language uses the "there shall be appropriated to the Secretary out of any monies in the Treasury not otherwise appropriated." It's interesting that monies substitutes for funds and is not spelled consistently. Sometimes it's spelled M-O-N-E-Y-S and other times M-O-N-I-E-S. QIO language uses "shall be payable from" and then lists the hospital and supplementary medical insurance trust funds as the source. CHIP language is "there is appropriated out of any money in the Treasury not otherwise appropriated." The Medicare example is a bit different. Note the language "there shall be paid from the Federal Supplementary Medical Insurance Trust Fund." This meets the requirement of a directive to pay and a source. So as you can see, there is a lot of variety in the Statement of Appropriations. Just keep in mind that the wording needs to specifically use the term appropriate or enact a law expressly directing a payment out of a designated fund or source in the Treasury. This is a good time to revisit the issue raised in Module 1 about the Statement of Appropriations. You may recall that although there is no rule in the Dictionary Act for the Statement of Appropriations, the format used in annual appropriations acts has been fairly standard since 1798. However, the wording seems a bit redundant. If we only need to specify that funds are appropriated, why would the words "out of any money in the Treasury not otherwise appropriated" be necessary? In fact, there are specific cases where in codifying such appropriating language for particular permanent appropriations, Congress has left these words out. Let's take a look at some examples. In this example of the permanent appropriation for the Judgment Fund, note that the original appropriating language included "out of any money in the Treasury not otherwise appropriated" phrase. However, when the language was codified, this language was dropped, leaving the simpler "necessary amounts are appropriated." The notes tell us this language was omitted as surplus. In the permanent appropriation for the necessary expenses of the public debt, the original language was omitted as surplus as well. Finally, in the permanent appropriation for income tax refunds, again, the original language was simplified from "out of any money in the Treasury not otherwise appropriated" to simply "necessary amounts are appropriated." These codifications of permanent appropriations seem to suggest that the wording of appropriation language over the years could be simplified. Now let's go back to our summary chart of the elements of appropriation language from modules 1 and 2. The unnumbered paragraphs we saw in annual appropriations acts are not used in permanent and entitlement appropriations. Since appropriations are embedded in authorizing or permanent legislation, the language is located or referenced by a standard statutory numbering system as follows. It begins with the section as the basic unit of organization of a statute, followed by a subsection, the paragraph, the subparagraph, the clause, and the subclause. This numbering applies in both permanent legislation as well as the codified version in the United States Code. What about default availability? Recall from Module 1 that for annual appropriations, unless Congress specifically states otherwise, the default availability of funds is 1 year. Let's review the 3 reasons. Both the title of the Act and the Statement of Appropriations have already told us the funds appropriated in the Act are for the fiscal year ending September 30th, 2015. There's a requirement at 31 U.S.C. 1301 C2 that says an appropriation in a regular annual appropriations law may be construed to be available continuously only if the appropriation expressly provides that it's available after the fiscal year covered by the law in which it appears. And there's a general provision telling us that no part of any appropriation shall remain available for obligation beyond the current fiscal year unless expressly so provided herein. But permanent and entitlement appropriations are not made in annual appropriations acts. There's no mention of duration in the title of the act, nor is there a general statement of appropriations. 31 U.S.C. 1301C applies only to regular annual appropriations, and permanent and entitlement appropriations do not have general provisions. Based on my research, I have not been able to determine that there is a default availability for permanent appropriations, but OMB Circular A11 provides a hint. So let's review the definitions of period of availability in OMB Circular A11. When a law appropriates budget authority, it sets the period during which you can use it to incur new obligations. This is called the period of availability for new obligations of the budget authority. And the period normally is specified in the law providing the budget authority. Annual budget authority is authority that's available for obligation during only 1 fiscal year or less. We know from Module 1 that this is the default availability for annual appropriations acts. The phrases for fiscal year X and for each of fiscal years X through Y are typical for an annual or 1 year availability. Multi-year budget authority is authority that's available for obligation for a specified time in excess of 1 year. The phrases available for obligation through a particular date, available for obligation until a particular date, and for the period of fiscal years X through Y are typical for a multi-year period of availability. No year budget authority is authority that is available for obligation indefinitely. The phrases available until expended or available without fiscal year limitation identify a no year or unlimited period of availability. And here is our hint. Note that A11 tells us that authorizing laws that make appropriations seldom limit the period of availability. So most budget authority provided in authorizing laws is no-year budget authority. Well, that may be true for HHS, but only barely. In 2016, for example, HHS no-year permanent appropriations made up roughly 57% of the total. 27% were multi-year and 16% were annual. This being the case, let's first focus on language that creates no-year availability. What language helps us determine this? Well, the clearest examples reflect the magic no-year words immediately following the amount appropriated. Here we see the phrase available until expended in the sentence immediately following the $50 million appropriation from the SMI Trust Fund. And here we see the phrase available until expended in the sentence following the $5 million appropriation from the SMI Trust Fund. In this example, we see available without fiscal year limitation in the sentence immediately following the $5 billion appropriation. These are examples where it's very easy to determine no-year period of availability. But there are other ways no-year availability is provided that require the reader to pay a bit more attention. In this example, note that the first phrase we encounter looks deceptively like an annual appropriation for each of fiscal years 2010 through 2014. But then the magic available until expended phrase is added at the end. Here, for fiscal year 2009 looks like an annual appropriation. And for the period of fiscal years 2010 through 2012, looks like a multi-year appropriation. But we get available until expended language at the end. Note that this language, appropriated for the 5-year period beginning on January 1, 2011, seems to suggest a multi-year account, until we see available until expended language at the end. Here, we also see what initially appears to be a multi-year availability as well, until we get to paragraph 2. Why would Congress write the availability language this way? Are they just making sure we're paying attention? One reason to consider is that since appropriations in permanent law are not made on a regular annual schedule, as in annual appropriations acts, Congress needs to clearly identify the fiscal year or years the funds are being provided for. So in these cases, the phrases for the period of fiscal years 2010 through 2014 or for each 5 fiscal year period thereafter are not intended to determine the availability. Rather, they merely identify the year or years the funds become available. The fact that the period of availability is then added at the end seems to confirm this. But we need to be very careful reading the language. If there is no later statement clarifying the availability, we may have to fall back on our initial interpretation. We'll see examples of this shortly. This means that in the context of appropriations made in permanent law, we have to read all the relevant language carefully. We cannot assume for fiscal year X or for the period of fiscal years X through Y language establishes annual or multi-year availability without reading the entire legislation. In this example, for the World Trade Center Health Program Fund, notice that the language initially sounds like annual language for fiscal year 2016 and each subsequent fiscal year. But notice in paragraph 5 that Congress takes great pains to make all the funds available until expended. And in this example, we see a list of amounts appropriated for fiscal year X, or for each of fiscal years X through Y. But at the bottom, there's a section entitled Availability, and that makes it clear the funds are available until expended. All of these examples suggest that one cannot assign availability to an amount appropriated in permanent law until one has made a complete reading of the language. In some cases, this complete reading may of necessity be more extensive. Let's take a look at the appropriation language for the special diabetes programs. Here we see virtually identical language for the special diabetes programs in NIH and IHS. Note the for each of fiscal years and for fiscal year language that would normally suggest that these funds have annual availability. However, Public Law 1087 made the special diabetes programs for Indians funding no year by virtue of the available until expended language. How are you supposed to know this? By keeping up with any legislation that subsequently amends the appropriation. This is another good reason to check for permanent appropriations in the U.S. Code. If they have been codified, all relevant amendments will ultimately be identified in the codification. Note, for example, this addition to 42 U.S.C. 254 C.3. I should point out, however, that this did not change the availability of the NIH diabetes funding, which remains annual. The fact that Congress felt the need to amend the original IHS appropriation language suggests to me they did not consider for a fiscal year language flexible enough to provide more than annual availability. But before we leave this example, I want to point out that where appropriate, permanent law appropriations typically provide an annotation identifying the location of the language in the U.S. Code. Note the 42 U.S.C. 253 C.3 annotation here. These annotations can be very helpful when searching for appropriation language in permanent law. In all of these cases, the no-year language overrides any annual or multi-year language. But these examples suggest that you need to read all the relevant language carefully. What might initially appear to be annual or multi-year availability may turn out to be no year later, either in the same or different piece of legislation. And you need to keep track of any amending language that may have changed the availability. But what happens if Congress doesn't use any magic words? Is it possible to have no year funding without the magic words? Well, yes, but the need for no year funding must be implicit in the language. In this example, for the implementation funding for the Affordable Care Act, we see an appropriation of $1 billion for federal administrative expenses to carry out such act. There are no recognizable phrases indicating any of the availabilities we've seen. But note that these funds are to carry out the act. Given that the act was passed in fiscal year 2010 and the implementation was expected to cover many years, the most reasonable period of availability interpretation was to assume these funds were indefinitely available. Based on this understanding of the context of the language, it was determined by collaboration with OMB and Treasury that the funds were available until expended, or no year. Here's another example of implicit authority. This is the appropriation language for the maternal, infant, and early childhood home visiting programs from the Affordable Care Act. Note the for fiscal year language. This led to an initial determination that the funds were annual. However, take a look at the language under availability. It says that any funds that are not expended by the eligible entity may be used for grants to nonprofit organizations. This requirement led to a reevaluation of the period of availability. It was ultimately determined, again by collaboration with OMB and Treasury, that this program requirement to reallocate grants required the account to have an indefinite or no-year period of availability. Let's take a look at one more slightly different example. The co-op program under the Affordable Care Act received an appropriation for $6 billion. The initial determination of period of availability involved a careful reading of the appropriating language. There are hereby appropriated $6 billion to carry out this section, in conjunction with the time for awarding loans and grants section. It was initially determined that this was a multi-year appropriation since the statute limited the time for loans and grants to the period 2010 to 2013. But it was later determined that administrative expenses, implicit in the to carry out language, would need to remain available beyond the loan and grant period in order to finance closeout functions. Based on this continuing need argument, OMB and Treasury agreed the administrative cost portion of the appropriation required no-year authority. Let's pause for a moment and summarize the takeaways on no-year availability. First of all, if you see the magic words available until expended or available without fiscal year limitation in the appropriating language, either immediately conjoining the statement of appropriations or following in a separate paragraph or in amending legislation, even if there is other language suggesting otherwise, it's a slam dunk. The funds are no year, and your analysis is done. If an appropriation has none of the period of availability phrases, either annual, multi-year, or no year, but the purpose of the funding continues for an indefinite time, as in the case of the ACA implementation and the maternal, infant, and early childhood home visiting program accounts, it's probably no year. But in the absence of explicit language, you would need to consult with your Office of General Counsel and have OMB and Treasury approval. If an appropriation's programmatic purpose has ended, but there is a continuing need for funding, for example, administrative funding to close out the program, an argument can be made to make these administrative funds no year. But again, you will need to involve the Office of General Counsel and seek OMB and Treasury approval. Now, let's take a look at multi-year period of availability language. Multi-year budget authority is authority that's available for obligation for a specified time in excess of one fiscal year. It may be 2, 3, 5, or more years. Roughly 27% of HHS accounts receiving permanent authority have a multi-year period of availability. The phrase that we look for are available for obligation through a particular date, available for obligation until a particular date, which oddly enough both mean the same thing, for a period of fiscal years X through Y, and even for the period of fiscal years X and Y are typical for a multi-year period of availability. But remember to read carefully. This appropriation in paragraph E8 of the Childhood Obesity Demonstration for the period of fiscal years 2016 and 2017 resulted in a 2-year account. But similar language in paragraph I for the Child Health Quality Measures activity in the same bill was overridden with available until expended language. So, if you see the magic words, available for obligation through a particular date, available for obligation until a particular date, or for the period of fiscal years X through Y, and there's no later until expended language added, either later in the legislation or in amending legislation, and there's no implicit continuing need like we saw with the co-op account, then the availability is probably multi-year. It should be obvious by now that we have to read the language carefully to make sure there is no later statement of available until expended that would override any multi-year language. We also need to make sure no amendments have changed the availability, and we need to make sure there are no implicit programmatic reasons why, for example, administrative funds need to remain available until expended to cover a continuing need. Okay, finally, let's take a look at annual period of availability. Recall from Module 1 that a period of availability of 1 year is the default availability for annual appropriations acts. But interestingly enough, not only is it not the default availability in permanent appropriations, it also doesn't appear nearly as often as no year and multi-year language. For example, only 16% of HHS accounts receiving permanent authority have a period of availability of only 1 year. This may be because permanent appropriations are not revisited on an annual basis like appropriations in an annual appropriation act, so Congress tends to make the funds available longer. So, what would annual availability in a permanent appropriation look like? Well, here are some examples. Phrases like for fiscal year X or for each of fiscal years X and Y seem to suggest a single year of availability. We also see examples of this language here and here. But recall that when we saw this language in earlier examples, it was frequently followed by available until expended language, leading to the conclusion that the phrase was not intended to determine the availability in those cases, perhaps serving merely to identify the year the funds were appropriated. In the absence, though, of follow-on available until expended language or extenuating programmatic reasons, these words leave us with the conclusion that the funds are available only for a single year stipulated. What other factors might support this conclusion? We've pointed out in several other period of availability examples that context is crucial. Look at the programs the funds are appropriated for. If the appropriating language is written in such a way that funds could not be obligated after 1 year, the funds should be considered annual. As an example, let's take a look at the abstinence education program. Note the appropriation language in paragraph D, an additional $75 million for each of fiscal years 2016 and 2017. For each of fiscal years 2016-2017 suggests a single year of availability. In addition, there are no other indications of an extended period of availability. Furthermore, note in paragraph A that allotments or grants to states are limited to the amount appropriated for the fiscal year in paragraph D. This language, read in context, suggests that abstinence education funding was not intended by Congress to be available for more than 1 year. Here's another example. This one's from the Affordable Care Act. This is the language for the grants to states to establish health benefit exchanges. Note that it appropriates an amount necessary to enable the Secretary to make awards, and this amount is specified for each fiscal year. There's no explicit statement of period of availability. However, it was determined from the purpose of this language, that is, making grants to states to assist in establishing exchanges, that the intent was for an indefinite amount necessary to make awards to be available only for each year the Secretary had to make awards, 1 year at a time. As you can see, determining period of availability requires a fair amount of analysis. Nobody ever said this was easy. What other factors might help us determine whether funds really are annual? We've noted the need to carefully read the legislation. Another thing to consider is a principle of statutory interpretation that tells us statutes should be internally consistent. Let's look at an example. Here are 5 appropriations from the Improving Medicare Post-Acute Care Transformation Act of 2014, or IMPACT Act. This act was relatively short, 18 pages. Note that each of these paragraphs uses the available until expended language, but not this one. When Congress passes a particular piece of homogeneous legislation that carefully articulates a no-year period of availability for all the appropriations but one, then it's very likely they intended a period of availability with 4 fiscal year language and not available until expended language to be available for a single year. I should point out that while this analysis might work for relatively short, homogeneous pieces of legislation like the IMPACT Act, it would not work very well with a large, heterogeneous piece of legislation like the Affordable Care Act. Okay, let's summarize what we know about annual availability in permanent law. If you see certain phrases like for fiscal year X or for each of fiscal years X and Y, and there is no later statement of available until expended that overrides the initial reading, either later in that legislation or in amending legislation. Keep in mind the Indian diabetes funding example. And if there's no implicit continuing need, like we saw in the Affordable Care Act Implementation Fund or the Maternal, Infant, and Early Childhood Home Visiting Program, if when you read the statute as a whole, if there's no way the program could even spend the funds in a subsequent year anyway, like our abstinence education grants example, if every other appropriation in a relatively short, homogeneous bill was expressly available until expended except one, and that account had for each such fiscal year language, then the account's probably only available for 1 year. Notice I use the word probably. If there's any doubt about availability, you should always consult the Office of General Counsel. Let's go back to our pie chart. I've been focusing on the red slice of the pie, permanent budget authority, which makes up 46% of HHS unexpired accounts. So far in my discussion of permanent appropriations, I've focused only on appropriations made from either the general fund or from the Medicare trust funds. But there are 2 other types of permanent appropriations that I have not discussed: gift funds and special funds, represented by this portion of the red slice in the pie chart. In addition, though the modules are focused primarily on appropriations, I mentioned earlier that I would touch on permanent offsetting collection authority, represented by the green slice. These are the remaining accounts that have budget authority provided by law other than appropriations acts. What makes these different? To answer that, let's review what's meant by the power of the purse. Recall that the Congress controls the money going out of the Treasury. Article 1, Section 9, Clause 7 tells us that no money shall be drawn from the Treasury but in consequence of appropriations made by law. But Congress also controls the money going into the Treasury by the Miscellaneous Receipts Statute, which tells us that funds received by the government must be deposited in the Treasury. Until now, we've focused our discussion of appropriation language on the authority to take money out of the Treasury. But to complete the picture, we need to consider the Miscellaneous Receipts Statute side. There are certain exceptions that Congress has provided in statute to the requirement that all funds be deposited in the Treasury, thereby needing a subsequent appropriation to use them. These exceptions include gift funds, special funds, and spending authority from offsetting collections. Spending authority from offsetting collections can be divided into offsetting collections credited to accounts and revolving funds. Let's first take a look at a sampling of language that we might encounter for gift funds. The first sample is the gift fund authority for 12 of the 14 HHS gift funds. Note the language codified as part of the PHS Act at 42 U.S.C. 238 authorizes the Secretary to accept on behalf of the United States gifts for the benefit of the service. These gifts shall be deposited in the Treasury and are hereby appropriated and shall be held in trust by the Secretary. This gift fund authority establishes small trust funds which receive donations that can then be spent without further action from Congress. Because this authority authorizes HHS to spend gifts received, it meets the conditions of an appropriation. In addition, given the nature of a trust fund, that is, the investment of funds for future use, these gift trust funds always have an indefinite period of availability. So all gift funds are available until expended. Here we see another gift fund authority for the Administration on Community Living. Notice this authority explicitly states that the funds shall be available until expended. Gift funds make up roughly 2/3 of this slice. Special funds make up the remainder. Let's take a look at a couple of special fund authorities. In this example from the Technology Transfer Act, Cooperative Research and Development Agreements, or CRADAs, were given the authority to accept, retain, and use funds collected from a collaborating party. Since a special fund is established when the law requires the earmarking of funds from a specified source to finance a particular program, this type of language provides authority to establish special funds in FDA, CDC, and NIH for these agreements. Here we see the authority for the Indian Health Service to collect rents and charges for quarters provided into the applicable appropriation or fund. This provides the authority for a special fund established for this purpose. The period of availability of special funds is determined based on the purpose of the fund. The CRADAs were determined by a Treasury legal opinion to be no year, based on the retain and use language in the authorization. The rents and charges special fund was also determined to be no year, based on the purpose of that fund. In fact, the period of availability of 94% of special funds in the entire federal government is no year. The 10-year Pediatric Research Initiative Special Fund, however, was one of the 6% established as an annual account. This is because the fund was established only to collect and subsequently appropriate $12.6 million each year to NIH, but only as provided in advance in Appropriations Acts. As we recall from Module 1, the default availability in annual Appropriations Acts is 1 year. In addition, since these funds are collected and transferred out each year, anything in excess of annual availability would be unnecessary. Now let's take a look at offsetting collections. Technically, as discussed previously, since the topic of these modules is on reading appropriation language, and offsetting collections are a different form of budget authority, they are not included in our universe for appropriation language. But in the interest of completeness, let's take a look at the kind of language we might see for permanent authorities to collect funds. These make up 6% of HHS permanent accounts and are of two types: revolving funds and other offsetting collections. Let's look at revolving funds first. These make up 38% of the permanent offsetting collections. Revolving funds are authorized by Congress to sustain enterprises of the government, which are of a business nature. This example shows the authority for the HHS, NIH, and CDC revolving funds. This authority permits the collection of funds for certain cross-cutting services. Note that the fund is established without fiscal year limitation. This is typical for revolving funds. Another business type service that Congress might authorize is a loan program. Here we see the generic authority under the Credit Reform Act to establish necessary financing accounts. This last example is the revolving fund for certification in FDA. Note the explicit without fiscal year limitation language provided. What about other forms of spending authority from offsetting collections? These make up the remaining 62% of permanent offsetting collections. Here is another example from the Technology Transfer Act authorizing the collection of patent royalties. In this case, note the language establishing availability. The royalties may be obligated during the fiscal year in which they were received or during the 2 succeeding fiscal years. This establishes a multi-year account availability of 3 years. FDA, NIH, and CDC all have accounts established under this authority. One of my favorite examples is the semi-postal. This language from 39 U.S.C. 414 for special postage stamps authorizes the breast cancer stamp, which allows NIH to receive 70% of the amounts collected and to use those funds for breast cancer research. There are, of course, many other permanent authorities that permit an account to accept offsetting collections that I've not mentioned. The Government Employees Training Act, the Stafford Act, the Economy Act, and so forth. But these authorities permit the collection of funds in accounts that also receive annual appropriations. So they are included in the 54% or blue portion of the chart. My intent in this module has been to focus on accounts which receive resources exclusively from authorities established in permanent law. Let's wrap up by summarizing and comparing how we answer our 5 basic questions concerning appropriations. First, who is receiving the appropriation? Recall that if the Appropriation Act is standalone, the Appropriation Act title and Statement of Appropriations will typically identify the Appropriation Subcommittee. The Roman numeral titles identify the federal agency or group of agencies. The heading identifies the bureau or optive within the federal agency, and the subheading identifies the account. And of course, Treasury assigns a symbol for each account. With a CR, we do not have this information. Rather, we're given a roadmap to find it by referring to the previous year, which has all of the identifying information listed above. In permanent law, we don't have the logical structure of the Appropriation Act, so there's rarely any explicit indication who is receiving the appropriation. This is typically assigned by determining the purpose for which the funds are appropriated and assigning the funds to the organization performing that purpose. For example, funding to improve Medicare or Medicaid would go to a CMS account. Funding for the aging community would go to ACL, and so on. Question 2. What's the appropriation for? In regular and supplemental appropriations, the purpose statement is typically the prepositional phrase that leads off the appropriating language in an unnumbered paragraph, with such words as for carrying out, for necessary expenses, for making payments, and so forth. To find the purpose in a CR, again we follow our roadmap back to the appropriate reference in the previous year. In permanent law, the purpose is typically stated in the legislation appropriating the funds. But you may have to read the legislation very carefully to figure this out. Keep in mind that language that we saw in Module 1, like for carrying out and for necessary expenses or for making payments and so forth, will also help us here. It's also worth noting that Treasury policy requires that new permanent appropriations for purposes already funded be appropriated to existing accounts that currently carry out those purposes. New accounts will be established only for purposes not already funded. Question 3. How much is being appropriated? In regular and supplemental appropriations, the amount appropriated typically follows the purpose statement. This amount is definite in most cases, but for appropriated entitlements may be indefinite. In a CR, we can't find any amounts. Section 101 tells us to look at the rate of operations of the previous year incorporated by reference for discretionary programs. And Section 111 provides rate to maintain current law for mandatory programs. Mandatory estimates are generally available in the mid-session review of the President's budget for the budget fiscal year. In permanent law, amounts are typically included with the appropriating language. In some cases, just as with annual Appropriations Acts, the amount might be indefinite. Such amounts are identified by such sums as may be necessary language. Question number 4, how long is the appropriation available? In regular and supplemental appropriations, the default period of availability is 1 year, as stated in the Appropriation Act title. If Congress wants a longer period of availability, it must be expressly stated. In a CR, it's a bit more complicated. First, we need to consider the duration of the CR. CR funding can't extend beyond the duration date. But we also need to consider the period of availability that needs to be assigned for accounting purposes. This can be determined either from extent and manner language in Section 103 or conditions language in Section 101. This period of availability will become important when the CR becomes a full year appropriation. In permanent law, we first look to see if the magic words indicating no year, multi-year, and annual availability are explicitly stated and not overridden by language elsewhere in the legislation or in subsequent amendments. Then we look at the context of the appropriation to determine whether any initial determination might be affected by that context. If there's no explicit period of availability, then the context of the legislation is examined to determine the most reasonable period of availability. In permanent law, the Office of the General Counsel, OMB, and even Treasury are frequently involved in the determination of period of availability. Question 5. What conditions are there on the use of the appropriations? In regular and supplemental appropriations, there are several places to look for conditions or provisos. The appropriation language itself has conditions identified by the italicized provided and provided further language. There are general provisions that apply to titles within an appropriation act. General provisions affecting HHS appropriations appear in Title VI of the Agriculture Act, Title III of the Interior Act, and Title II of the Labor, HHS, and Education Act. There are general provisions that apply to all the appropriations within an act. General provisions affecting HHS appropriations appear in Title VII of the Agriculture Act, Title IV of the Interior Act, and Title V of the Labor, HHS, and Education Act. And there are government-wide general provisions that appear in Title VII of the Financial Services and General Government Act that apply to the entire federal government. A continuing resolution, of course, is all about conditions. Some conditions are the same as the previous year, that is, they're incorporated by reference. Some are added as normal CR components, and some are added as anomalies. In permanent law, you don't normally see general provisions, and none of the general provisions in annual appropriation acts apply. You won't usually see the italicized provided that and provided further language highlighting conditions that we saw in Annual Appropriation Act language in Module 1. However, the conditions may appear buried in the text, perhaps far away from the appropriating language itself. Conditions would be determined by an in-depth examination of appropriating language and the body of legislation. Well, this wraps up Module 3. Let's recap. In Modules 1 and 2, we discussed the appropriating language of two types of current budget authority: regular, including supplemental appropriations, and continuing appropriations. Slightly different, though still all too common way of providing appropriations. These two forms of current budget authority are the most common means of providing appropriations and the ones we're most familiar with. 54% of unexpired HHS accounts receive current appropriations. In Module 3, we discussed the language of permanent budget authority. This is budget authority that's available as the result of previously enacted legislation. 46% of unexpired HHS accounts receive permanent appropriations. We focused most of our attention on appropriations, which include gift funds and special funds, but we also touched on permanent spending authority from offsetting collections. We found that reading and understanding permanent appropriation language is a very different and difficult undertaking than reading and understanding current appropriation language, because permanent appropriation language lacks the consistent structure that we saw in Modules 1 and 2. Because of this, reading permanent appropriation language often involves discussions with the Office of General Counsel, OMB, and Treasury.
This concludes reading appropriation language. I hope you found this presentation useful.